On behalf of the appellant, I also have with me a law clerk from my office, Justin Hunter. I would like to reserve, if I could, 3 minutes for rebuttal.
Okay. You'll see a yellow light when you're getting to 3 minutes. Okay.
Thank you, Your Honor. I just want to give a little bit of context to this case. As I believe Your Honors are aware, my client, Hecht Consulting Corp., is generally one individual. Miss Island had Hurricane Wilma damage and basically was underpaid by her insurance company. She then hired Mr. Hecht and his company in 2007, who did a bang-up job for her and actually got her 350 times what the insurance company had offered. He did that via the appraisal process. Once checks were issued, the checks were issued with both Mr. Hecht's name and Dorothy Island's name on the checks. Miss Island, from day one, refused to pay my client for his work and services, and although there was some negotiation early on, Miss Island sued my client basically to try to not pay him and to get the checks issued directly to her without paying him at all. There was some issues regarding the endorsement of the checks. My client then filed a counterclaim in 2008. That counterclaim and continued issues regarding the breach of contract claim actually went to trial. The trial occurred in 2011. The defendants were victorious. We actually agreed to a remitter because the jury gave us more than we had requested at trial. Post-trial, there was considerable litigation that lasted until today, but basically 3 years of aggressive, contentious litigation. At that time, we filed a number of motions for fees and costs, and the plaintiff also filed motions for fees and costs. The court very specifically granted entitlement to the defendant, my client, for attorney's fees and costs quite a number of times, quite a number of ways. Although entitlement was granted, we find ourselves in a position here where there's entitlement to fees and costs after a jury trial, and the lower court has inexplicably refused to provide a number or an amount as to the fees and costs that should be awarded after entitlement. And so in essence, what the court has done is vacated a prior order or not followed through with the order in terms of entitlement. So that's essentially what we're here today, and there are two interrelated issues, and it's basically fees and costs, which counsel and the court has taken to be one prevailing issue post-trial as to this particular case. And those issues are related very specifically because the trial court determined that my client was entitled to fees and costs for the counterclaim. And we had our evidentiary hearing where we had expert testimony. Mr. Hecht was there. He provided testimony. We filed 3 sets of affidavits, one for fees, one for costs, so that's a total of 6 affidavits as to this, and we filed very detailed billing statements. At the our evidentiary hearing where the expert testified, I physically raised up to the court and offered the very detailed billing statements, which are kept on Time Matters, which definitively record the times and costs that were spent on the case. The judge at this particular hearing specifically said, listen, I don't want the documents. It's too much paperwork for me. Please don't give them to me. And then there was basically 2 years of litigation regarding not the substance of the amount of fees and costs, but the format in which the judge wanted those provided. And essentially what the judge wanted was something that very specifically delineated just the counterclaim amounts and just the counterclaim costs, but would not take into account anything that would be intertwined. And what was explained to the judge on numerous times is that this computer program, when it prints it out, and this is billed to our clients, you can't simply pick and choose things to take in and out of this. And so what we did was we provided the entire billing transcripts to the court for the court to review, and then we also were able to generate another billing transcript that was from the date of the counterclaim on. This went along with what the expert had testified to, where the expert reduced the amount of bills of fees and costs by $30,000 specifically related to the counterclaim. But what the court wanted was, I think, a different bill that only related to specific issues, which this program simply cannot generate. So these, again, were specifically held up physically in front of the court. We asked if we want to provide it. The court said, no, we don't want this documentation. And then we went on a number 4 or 5 hearings thereafter as to the form and exactly what the court wanted within the documents. There were a number of affidavits that were filed after that initial hearing that tried to...
I'm hearing you say that your computer program doesn't allow you to, so to speak, redact certain things out. But at any point in time, was the printout of everything that your computer would generate gone through, and whatever wasn't applicable, you know, a black marker was used to black that out?
Exactly, Your Honor, and that was very specifically what we did when she asked us again to redact, is because we couldn't change the billing program, we took a black marker and took some of the sections out. Now, if you look through the briefing, the judge made an issue and opposing counsel made an issue with the timeliness of an affidavit that they said at a hearing he hadn't received. Our position was, first of all, that he had received it. It was filed on e-service.
But it's that, so to speak, hand redacted document, which is the one that the court had a concern was given late.
That's correct, Your Honor. And so it was the actual same document with an affidavit. The affidavit delineated it specifically saying this is just the counterclaim, and the back pages, which are part of the bill that relate to cost, were just black markered out because that's the only way our office knows how to provide that information to the court. So there wasn't any surprise or any issue with the documents. It was simply the same document with some redactions made in actual black marker. Your Honors, again, we think that it's a very simple case where we have a defendant who prevailed at jury trial. There was entitlement to fees and costs, and there was no order that was provided as to those amounts. And so I understand that the court was a little bit disappointed in the format of the documentation, but we had an expert that testified, we had the client that testified, we provided multiple sets of affidavits over a course of 3 years, including full billing documents as to exactly what was done on this case. And as Your Honors are aware, the court must provide fees and costs in this case when there is a ruling definitively as to entitlement, and for the court to then say we're granting entitlement to fees and costs but we're refusing to provide an amount is improper, and it must be reversed and remanded. Thank you, Your Honor.
Good morning, Your Honors.
Good morning.
My name is Anthony Tito, and I represent Dorothy Island. And I have with me Steve Mancodi, he's the law clerk in my office. First, I think maybe I'll clarify something that was just said. The affidavit with the blackout, that was at the cost hearing, the motion to get court costs, which was the third attempt. The judge in the court below exercised tremendous patience with Mr. Neblett and his client. Even from the get-go, when they refused to turn over the checks that Judge Henning ordered them to turn over. Extreme opportunity, there was a show cause order. He makes it seem like my client didn't want to pay anything. That's not true. My client at all times offered to pay the 10%. This is the contract, 10%, at all times. But going back to that affidavit, since it was mentioned, Hecht's counsel, Mr. Neblett, admitted at the hearing, if you look at the record, R1352/L910, that's the hearing, the transcript from that hearing, that he admitted that the affidavit attached was the incorrect one and was not the redacted one which he attempted to introduce at the hearing. First time I saw this redacted affidavit, which, by the way, is just a piece of paper with some lines through it, no totals, nothing, if I can remember that, was at that hearing. So he never did what the judge told him to do regarding court costs. Never once did Mr. Neblett take the time to list in an affidavit form what his court costs were relative to the counterclaim. I, on the other hand, prevailed on the first two parts of that case, which was my complaint. If you recall, I had a complaint for declaratory decree and injunctive relief. I obtained a temporary injunction, affirmative relief. He was supposed to give the checks to me according to that court order. and he refused to give me the checks. And then he told the judge he didn't have the checks, even though attached to my complaint is a letter from Mr. Neblett, 2007, where it says, "Please note that I am in possession of the checks issued by FIGA for this claim." Then he goes before Judge Henning and says, "I don't have the checks. My client has the checks." So she had to issue an order. We had to go through all this work, ordering FIGA to issue new checks. By the way, the money that she told me to hold in my trust account was a lot less than what his client was asking for. Attached to my original complaint, you will see that in addition to the 10%, Mr. Hecht wanted an additional $6,000 for a company called First Priority Restoration. Okay? Also, in the letter that I received from Mr. Neblett, which is attached to my complaint, he wanted $3,000 for a mold report and $250 for a contents report. These are monies that he never received. The only money he received was the 10% plus an additional $4,000 for an appraisal that he did. Okay. When he came before the court on the entitlement, the court made it very clear, because I received attorney's fees. As a matter of fact, I have 2 outstanding judgments for attorney's fees against this client. I received my attorney's fees and court costs. I did it the way it was supposed to be done, that were necessary, reasonably related to what I did. I got the judgment. His client naturally didn't pay it. I had to garnish his account, but I eventually got paid. So when he completed his last part of the case, which was a small part of the case, we're talking about $37,000 here. My client, takes care of old people. She's a caregiver. She's living in a house that's leaking. He's holding the checks as ransom for his money. So anyway, what ultimately happens? He gets an entitlement as to his fees. Fine. Then the court denies his motion to determine the amount of fees because he refuses to take the time to present to her attorney's fees relative to the counterclaim. He just wants everything. He wants attorney's fees for defending his case against my injunctive relief action, which, by the way, was reviewed by this court. He even included fees for handling the appeal that he lost. The court had no choice. The court had no choice but to deny the fees. Then what happens? He comes up with a motion for reconsideration, which to me really was something. And he brings it up here again. He tells the court that it's the court's fault that I don't get my fees. And he puts in an allegation that the court told him that he shouldn't use the time slips and billing. And so the court, in response to that order, she issues an order, says, the defendant shall within 20 days from the date of this order supplement this motion with those portions of the transcript of October 18th. The defendant asserts that the court stated, quote, the court stated that it did not want the detailed time slips and billing records that were being proffered by counsel. 20 days. Never produced that item to the judge. And when he finally filed the transcript over a month later or 2 months later, guess what? It didn't contain that. It didn't contain that. Now, took no other action. Did not appeal the judgment for against him for attorney's fees. Why we are here on that issue is beyond my imagination. All right. He does not appeal the matter pertaining to attorney's fees. And then when he comes up for the court costs, he does the same thing. Refuses to take the time to put together a proper affidavit that shows what court costs. Don't forget, this was a counterclaim. He didn't even have a filing fee. Right? And all the case was really about the $37,000, not the $4,000. In any event, he doesn't file an appeal for the judgment against him on fees, and then he files a notice of appeal on the judgment, which I'm sure you've read, the judgment of the judge. The judge gave him 3 bites of the apple. It was really a simple thing to do, but he just refused to do it. So what does he do? He files a notice of appeal with this court, where the notice of appeal makes no mention of the denial of attorney's fees. So why are we here listening to his claim for attorney's fees? Okay? No appeal of the court's order denying the fees, no appeal denying the motion for rehearing, which was, we went from 12/5/12 to 13/13. Then he files a notice of appeal on November 5/13 and on the order on costs only. Okay? So there has never been to this court a notice of appeal pertaining to the attorney's fees issue. And if you look at American Casualty, I supplied all these cases, I gave supplemental cases, says that you have 2 separate claims here, separate appealable claims. Everything that's been presented to this court regarding the attorney's fees, to me, is a frivolous appeal, and that this court should take some action in that regard. Okay, I think you should look at the Connor case, the HSB Bank case. We've wasted a lot of time. By the way, we didn't find out about this claim regarding the attorney's fees until we read the brief. When we got his brief, we said, wow, he wants the attorney's fees. Okay, so total surprise. Total.
View that the better course of action would have been to have filed a notice of appeal at the time the order denying fees as to amount was entered, if not the motion denying the motion for reconsideration was entered. But I'm looking at the face of the order that was appealed, which clearly on its face in its first paragraph says it had to do with the motion for costs pursuant to 57041, the motion to tax costs. But within the face of the order, the judge, for whatever reason, on motion to tax costs, makes reference to the fact about the time expended on the counterclaim, and then talks about the billing time reflected for the work performed on the counterclaim. So, for whatever reason, the trial judge is mixing the apples and the oranges in this cost order, just describing work done, the attorney's fees on the counterclaim. So, just tell me why we shouldn't consider the fact that the judge, for whatever reason, included these references to the attorney's fees as somehow saving the appellant on the jurisdiction issue.
Well, I think we've provided cases that show that the time ended when it ended. And I don't read that order the same way. Maybe she was looking for reasons to explain why she denied the court course. But I know that the trial court judge, was very reasonable and understanding, gave all these opportunities. She was accused of causing him to, and actually he was blaming the court for his own action and his own inadequate preparation regarding the thing for fees. I look at it differently. I don't think that opens the door. I think he had an obligation to, and I think the case law says that, they're 2 separate things. And maybe the court alluded to it, but it wasn't an order pertaining to the attorney's fees. It was an order pertaining to the court course. And that's all he has a right to appeal. All right.
You're in your rebuttal time. I mean, no, you have no rebuttal time.
All right, I'm done.
A minute and a half over.
I just want to thank you all. It's been a long time since I've been here. I've been here many times, but see, we're in the same room.
Welcome back.
Nothing much has changed. Thank you.
Your Honors, very briefly, at that last evidentiary hearing, the judge asked me specifically regarding the affidavit, and the document in my file that I had brought with me, and this came out of the blue, did have something attached, and so I was unable to make a representation to the court. But I do know, and opposing counsel and everyone agreed that that was filed with the court. There was an issue with the e-service, and if he had received it, but again, it would just be redacted parts of the cost documents. In terms of the affidavits themselves, I hope that Your Honors will take a look at them because I believe they were filed something in the area of 13 different times, and there are 3 sets of affidavits for fees and costs. And if your honors just take a look at those actual affidavits, they very clearly delineate the counterclaim fees and costs. Specifically, I have an affidavit that says fees specifically for counterclaim costs only, and I have an affidavit that says costs for counterclaim only. And then it has attached documentation from the pre-bill that's redacted, so it was very clearly delineated. I urge your honors to look at that.
Respond to the question that I asked opposing counsel regarding the jurisdiction question. We're looking at the face of the order. It has these tangential references to the billing time on the counterclaim, but it's clearly not the order denying the amount of fees on the counterclaim. So why do we have jurisdiction no matter what the affidavits may show?
The court and counsel were arguing these all in total as intertwined. The particular day of the evidentiary hearing, we had set the motion for reconsideration and the motion of tax costs at the same time. If your honors look at the transcript, which unfortunately the court reporter ran out of battery power, but if you look at 1363, specifically the last part is the court had heard enough and said the court was denying both motions for fees and to tax costs.
Maybe I should ask the question this way. You had an order in hand at one point denying the amount of fees. Could have filed a notice of appeal right then and there in abundance of caution. Why didn't you?
Well, we filed the motion for reconsideration, and also in the transcript, your honor.
Let me interrupt then. Filed a motion for reconsideration. You ultimately didn't get an order to your satisfaction on that, saying you got an amount of fees. Why didn't you file a notice of appeal as to that?
Well, your honor, in this transcript too, the judge, lower court judge says, I'm entering an order encapsulating everything. And that's fully brief, but she says, I'm going to enter an order that takes care of the whole ball of wax. And we had been there 3 years post-trial. And so my understanding, and I believe everyone's understanding, was this order was supposed to take care of everything, and that's what we appealed.
Well, I'm now we're all looking at the face of the order. It doesn't appear that this last order is the whole ball of wax. It doesn't say anything about the amount, denying the amount of the fees.
Well, and that's because it was, I believe, relating to the previous order. I wish the order was a little bit more clear, your honor.
Did you ask for reconsideration to make that clear so you had an appealable final judgment?
Your honor, we appealed that. I didn't think to ask for any clarification, but as you can probably see through the transcript, the lower court was very frustrated with the process, and it seemed clear to me that she was saying, this is it. I'm not giving you anything. I know I granted entitlement to everything, but too bad. I don't like it. You're out of here.
And once the court reporter ran out of batteries, that was it. All right, thank you very much.
Thank you.
I've never heard that one before. That's interesting. Very interesting. You learn something every day up here. Okay, the next one up is J.P. Morgan versus Coletti.